Mr. Wyden.
Thank you, Mr. Chairman. Ambassador Kirk, it's good to see you, and thank you for always being so accessible. As chairman of our subcommittee here, our trade subcommittee, it's always been easy to get in touch with you, and I appreciate that. I want to start my questioning with the anti-counterfeit trade agreement matter that you and I have been discussing. This, of course, is an international accord that seeks to establish online intellectual property rights and disciplines in the intellectual property rights area. As we've talked about, many in our country believe that it raises many of the same issues that have been on the table in what's called the Protect IP Act and also the SOPA legislation, the Stop Online Piracy Act. Now, right before the hearing, the Obama administration sent me a letter indicating that they believe the agreement is legally binding. And that, of course, is in line with the conversation that you and I had late yesterday. So I appreciate that. And let me turn now to some of the implications, since the administration has now, and it's been a long time in coming, we've been talking about that, finally articulated a position that the administration considers the agreement legally binding. So my first question is, if I and my colleagues here in the Senate pass legislation to enhance competition and innovation on the Internet that runs contrary to the provisions of ACTA, could ACTA party nations retaliate against the United States or sue us in international court if we pass legislation like that?
Well, Senator, first of all, thank you for your strong interest in making sure that the United States has the strongest intellectual property rights protection for our industry, since I think we all understand a critical part of our competitiveness lies in our innovation, and we have to combat piracy and theft of that innovation around the world, and that is singularly what ACTA was designed to address. It would be difficult for me to answer a complete hypothetical on what other countries would do, but I would say ACTA, as in any other FTA that we have entered, does nothing to constrain this Congress from continuing to pass legislation to regulate in the interest of the safety, the health, the protection of America's families and our economy. So nothing in ACTA would constrain this Congress from acting in the future. And if Congress were to address additional IPR protections, then at that time we would work to Congress to make sure that our international commitments are left in place, or what steps would be necessary to protect us then.
Mr. Ambassador, respectfully, I differ on this point. It seems to me that this really boxes the Congress in on some very important questions with respect to promoting Internet freedom and competition and innovation on the net, because the Congress is now going to have to sort of be looking over our shoulder with respect to whether or not we've done something that could cause an ACTA party nation to sue us. So my question on this point is, all over the world, you've got parliaments and legislators having debates, the people's representatives having debates on whether or not to pass ACTA. Why shouldn't the United States Senate consider something like this? As you know, the traditional practice is when something is considered a treaty, a binding agreement, it comes to the United States Senate, comes to Chairman Baucus's committee. Why shouldn't the Senate be debating and considering something like this?
Well, Senators, we have had, I think, lengthy conversations with you and your staff, and I know you've written to us and State and others, and we've given you a written response to that. We believe it is a legally binding agreement entered by the executive administration, given with the authority given by this Congress. It has been used by previous administrations to enter agreements where Congress has frankly asked us to act. And you mentioned the 2008 Pro-IP Act. In that legislation, Congress expressly directs the executive branch, and if I might quote, to work with other countries to establish international standards and policies for the effective protection and enforcement of intellectual property rights. So this legislation, this initiative, this agreement was entered with the express direction of Congress to take these steps to make sure American innovation is protected around the world. And I won't draw an
Just
important
on that point, Mr. Ambassador, millions of Americans emailed and called the Congress with respect to Protect IP, and it was withdrawn at this time. Mr. Chairman, I know we'll have some additional questions, and I thank you for your courtesy.
Thank you, Senator. Senator Wyden.
Thank you very much, Mr. Chairman. A couple of other areas I want to get into with you, Mr. Ambassador, and then return back to the intellectual property issue, particularly as it relates to TPP, where we've had some discussions as well. On the TPP negotiations on footwear and apparel, you recently said the choice is cheaper tennis shoes versus jobs. And I know you had some discussion here with Senator Snowe, and I've heard you say that. I just think that's a false choice. I think we can have both. There's thousands and thousands of good-paying jobs in the design and R&D and marketing of footwear. And just to make clear, I want to work closely with you on this issue because I want those jobs and manufacturing jobs considered during the TPP negotiations. Now, second, on a housekeeping matter, I just want to make sure that the record is clear on that. You were at Ways and Means last week, and you mentioned that by one measure, the United States enjoyed a trade surplus in solar technology. And I think you know, and we've shown it to your office, I've done a report on this question of green goods, and my sense is what you were talking about were the 2010 trade figures, because the recent figures are out, and no matter how you measure it, in 2011, the U.S. suffered a massive trade deficit in solar technology, particularly in cells and modules that make up the solar panels. This reversal, in my view, is due to China. This deficit concerns me. I know it concerns you, and I just wanted to make that clear for the record as well. Let me turn and wrap up with some questions again about intellectual property, because the same issues that were on the table in the Protect IP Act, the Stop Online Piracy Act, the discussion we had with respect to ACTA, are now on ACTA, are now on the table in the negotiations about the Trans-Pacific Partnership Agreement, the TPP discussions. And I'm getting a lot of questions and complaints and concerns from people who care passionately about internet freedom, what's going to happen with respect to technology policy, about the fact that right now one is required to obtain a security clearance and permission by the administration to see documents relating to the TPP negotiations. And the public, particularly those who feel so strongly about this issue, which has generated enormous interest across our country, the public just feels shut out with respect to this debate about internet freedom and competition and innovation. And I just want to get a sense of why the administration agreed to a process for these discussions. It doesn't seem to me to be in line with the President's commitment to transparency and open government. And give me your sense about how we got into this, and then what can we do to turn it around? Because I think millions of Americans, as we saw in the discussion with Protect IP and SOPA, they want to be part of these discussions, and they're feeling locked out in one proceeding after another.
Well, Senator, if I might, if I can go back to one of my guiding principles when I was mayor and privileged to serve as mayor of Dallas, and we were in a situation like this, I would always tell my staff, the truth is an option. So let's go back to one thing. And one, you can be helpful. And first, we don't help ourselves by trying to conflate the recent debate over PIPA and SOPA with what we're doing in TPP, because nothing could be further from the truth, first of all. And so, one, you can help us in making sure people understand this is completely the opposite. None of the issues of which you had the most concern over those provisions in SOPA or PIPA are included in the TPP, first of all. So that concern is unfounded. And I think we have some credibility on this, because when we were negotiating ACTA, many of the same voices that raised legitimate concerns on PIPA put out a tremendous amount of misinformation about ACTA, which was subsequently shown to be not true. And what we are doing in our work in ACTA and TPP, frankly, is the opposite. We are trying to make sure that we promote the free flow of data and information. We have no provisions at all trying to restrict the flow of information, and we are following the same balanced approach in the TPP that Congress established when you passed the Digital Millennium Copyright Act. And they are complemented by what we're trying to do on market access opening provisions. So I think the first thing is to make sure we get the truth out. These are two different animals. Now, secondly, as I mentioned to Chairman Balkus and Ranking Member Hatch and others, we have engaged in more public consultations over this Trans-Pacific Partnership, probably by tenfold. Public consultations with Congress over all of our provisions that we have been negotiating. We've had over just 350 consultations with Congress alone, many more with our stakeholders. We have had stakeholders participate as observers in a number of our sessions, negotiating, including those that are concerned about these issues. And we are proceeding with the same negotiating parameters in this Trans-Pacific Partnership that the United States has negotiated every trade agreement over the last 20 to 30 years. So nothing that we are doing is different. We have moved to disclose more information sooner than any previous administration, as we did in the case of ACTA. But the reality is, because these are very complex negotiations, we are representing the United States and the President as your counsel, as are our other partners. You can understand there is a certain degree of discretion that has to occur in order to get these countries to sit down at the table and negotiate with us. But I would defend our record for transparency, for inclusion of all groups against any other administration. I think we've gone further, and we are absolutely acting consistent with the President's commitments that he made in terms of having a more transparent administration.
Mr. Ambassador, let's take your statement, and that's why I wanted you to kind of expand on your thinking, and juxtapose it along the lines of what people who care about these issues are coming to me and telling me. They're saying right now there is currently a requirement for a security clearance to see TPP texts and documents that can impact internet freedom. That's what people tell me, that they've got to have a security clearance to see the documents. So we put that alongside your statement. And let me ask you about something that might clear this up and actually get this resolved. What is wrong with letting the public see the text in real time of at least what your office is proposing as it relates to internet freedom? In other words, I've heard your views. I've tried to tell you what people are coming and telling me, and I'm saying to a public official who always looks to try to work with me, why don't we resolve this and resolve it by putting the text in real time of what the proposals are with respect to issues that can touch on internet freedom. It's certainly what people feel will touch on internet freedom. What would be wrong with putting that online so we could dispose of this issue, show that, once again, the President, who I know feels strongly about transparency and openness, is demonstrating that, and we put this issue to bed?
Well, again, Senator, we have moved. If you look at our modus operandi on our ACTA, as soon as we had enough of a convergence among our negotiating partners and we thought we had the text, we moved to do that. When we did, I would remind you, at least our office received a fairly stern message from the two committees who oversee my work that this not become the norm for USTR for the practical reason. And I understand the need. More of this is when we disclose, but the practical answer to what's wrong with putting it all out now, nothing, unless you don't ever want to negotiate a trade agreement. Because no one will sit at the table and negotiate us if we put all the terms of every text out. It's an evolving process. Secondly, with respect to the security clearance required, as you know, as chairman of the Trade Subcommittee, this Congress mandates that I have a number of trade advisory committees because of the complexity of trade deals. And you want to make sure that we have, first of all, thoughtful intelligence from those affected by that. all of them operate as what we call, Senator, cleared advisors. That is because of congressional law. And you give us the latitude for those who serve on these advisory committees and have passed the security clearance. We do share the text with those, whether it relates to internet or agriculture or pharmaceuticals or any of the multitude of trade advisory committees that we have. And that is one way that we make sure that we have the interests of different communities voiced and taken into account in our trade policy. It's a very thoughtful policy. It serves us well, and I believe it's the most appropriate way for us to go forward.
Mr. Ambassador, just see if we can wrap up on this point. I also serve on the Intelligence Committee. So day after day, I see just how you draw the bright lines with respect to security, clearances and matters that can be classified and deserve special treatment because of the implications they can have for national security in particular. I just think, and you mentioned the norm. The norm changed, Mr. Ambassador, on January 18th, 2012, where millions and millions of Americans said, we will not accept being locked out of debates about internet freedom. They just said, we've got to have a chance on something that is so important to innovation and competition. We've got to have a chance to be heard. And I'm not asking for everything to be published, and certainly respect your judgment with respect to issues that affect national security and classified matters. But issues that pertain to freedom and innovation on the net are policy questions. And the American people want a chance to participate. And I'm going to give you the last word on it, but it relates a bit to what we wrapped up with on the ACTA discussion. And that's one topic, and now we're having some of the same issues be raised on TPP. These questions are not hypothetical, Mr. Ambassador. They aren't. The prospect of the Congress of the United States passing a piece of legislation, for example, that changes the Digital Millennium Copyright Act and does it in a way that's inconsistent with ACTA, that's very real. These are not hypothetical, speculative questions. And we're not going to resolve all of them today, and I understand that. But what I hope we'll do, and what I want to take a few extra minutes, and I appreciate your courtesy on this, is to make clear how important it is that you throw open the doors of your agency so that the public can be heard with respect to their views on internet freedom. Because I thought you made an excellent presentation in terms of describing how you're handling the process. But when I walk out of this room, I'm going to get more calls. And they're going to say, I still got to get a security clearance in order to have a chance to see something about internet regulation. That doesn't make sense. So let's you and I see if we can work this out. Take away from this my position that I feel very strongly with respect to TPP about getting the proposals that you're looking at from a policy standpoint, not the classified matters, getting them online so that the public can have a chance to be heard on it. And I do, because I don't think these are going to be speculative questions. We learned on January 18th of this year that these issues are not speculative anymore, something that just kind of people are going to talk about in the abstract. They are very real. People want to be heard. Last word to you.
Senator, I could not agree with you more. There is no form of government that is closer to the people than local government. There's no form of, and no disrespect to the Senate or the Congress, I'm proud to serve here, but I understand the need for transparency in government as much as any other official. This president does. But just as we have a representative form of government, that's why we have elections. It's why you sit here, because the people of your state collectively understand everybody in your state can't come to Washington, so we have elected representatives who we count on that will express the voice of not just those you agree with, but those you disagree with. Then this Congress further refines and understands that while you retain the constitutional authority to enter commercial treaties, as a practical matter, this Congress is not going to sit down and negotiate with other countries. So you have ceded that authority to the administration. And part of that, you have directed us to have an advisory, a very balanced committee of advisors that represent a broad range of thought of those affected by trade policy. So all these voices, these concerns you've heard have been expressed. Now, I would submit to you again, and I agree with you, you and I are going to the same place, but I will tell you, Senator, we have done more to reach out to stakeholders across the board to hear their concerns, not just on issues of digital freedom, but of every element of what we are tabling within the TPP. But as you understand, as an elected official, hearing from all of these voices and everyone getting exactly what they want is two different things. I think we've had the most open, transparent process ever. We have taken more steps to put more information before the public in our websites, on our TPP websites than ever before. But we have to draw that balance between making sure that we have the space we need to negotiate with 9 very different countries who may have different thoughts on issues of internet freedom, of internet protection than we, and have that in a constructive way, while at the same time making sure that our public is confirmed. So we get to the point of making sure we keep our businesses and industries competitive. And that's what we've tried to do, is strike that proper balance. I think we've done that. I know you care about it, and that's why we will always listen for your thoughts and guidance on this. But I would just take issue that I do believe we have absolutely met the President's commitment of having one of the most transparent administrations ever.
I had promised you the last word, Mr. Ambassador, and I'll just amend that pledge for 10 seconds or thereabouts. There's no question that's the way it used to work. And I think what the public is saying is we've got to do better, and particularly because the internet is the engine of innovation, competition, and so many of the new jobs. So take away that you got a specific request this afternoon for at least putting the portions of the text, not the classified matters, that relate to internet freedom policy online. I think the American people want it. And with that, Mr. Ambassador, and your thoughtfulness, it's been a long morning. The Senate Committee on Finance is adjourned.
Senator, if I might make just one
of
final
course.
note, not on this, but this committee has had a remarkable ability of scheduling these hearings on my wife's birthday, which the first 3 were. This year, we missed it by 2 days, but notwithstanding, my wife will celebrate another milestone on Friday, and I think she's watching, so I did want to take this opportunity to wish her a happy birthday.
I like that a lot, and I'm sure she knows, since your Dallas days, the sacrifices for public service, and we appreciate what you do. Committee on Finance is adjourned.